Welcome to today's event organized by the Judicial Base South. My name is Dragan Đorđević. I am a human rights activist from the Human Rights Committee of Niš and a member of the program committee for the Judicial Base South Coalition. First of all, thank you very much for taking the time today to join us, and I bid you welcome to this event. Slightly more than 2 years ago, here in this room, the Judicial Base South Coalition first started work. Today we will present our second survey produced by the Judicial Base South. This is an assessment of the work of disciplinary bodies and disciplinary proceedings of the Niš Bar Association. This is a hybrid event in the sense that here with us we have in Niš the authors of the report, Professor Dr. Nevena Petušić, welcome. One of the researchers, Bojana Arsenjević, welcome. And Ms. Natasha Čirić-Išljamović. She's a lawyer and a disciplinary judge with the Niš Bar Association. Thank you and welcome. With us here today, we also have Mihailo Čolak. He's joining us via Zoom. He's a member of the Program Council of the Judicial Base South Coalition. I'm going to ask Mihailo to say a couple of words. Thank you, Dragan. There's always challenges with unmuting one's microphone, but I'd like to join in your welcome to all the participants. And without further ado, I propose we cut straight to the chase to start with the presentation of the report. Now, before we begin with the presentation, if you need interpretation into English, please switch to the English channel. Another important note that ought to be said is that the Open Society Foundation Serbia has supported this event, and I'd like to thank them for that. Ms. Petušić, you're the author of this study. Could you tell us more about the goals? Now, what was it that we set out to achieve, and what was it that we finally got from this survey? This is a pilot survey. To the best of our knowledge, no other bar association in Serbia has such a well-structured set of information about the performance of their disciplinary bodies. Well, first of all, thank you for having me, and I'm glad to have been able to take part in this research. I believe that a survey such as this, a pilot survey, an exploratory survey, it's the first of its kind in Serbia. I believe that it's helped us develop methodology for future studies of this kind. Now, this survey has given us an objective picture of how disciplinary proceedings are pursued at the Niš Bar Association and what the work of the disciplinary bodies looks like. And I'm very happy that the Niš Bar Association has been open to us and that they've shown interest. And I believe that they simply wanted us to gain this sound insight into how these proceedings are pursued and how these disciplinary cases are handled after disciplinary charges are brought. And in my view, this reveals how interested and how ready the Niš Bar Association has been to speak freely about these actions that run counter to the code of legal ethics and the readiness of the Bar Association to use its powers to counter these practices. This is a pilot survey, as you've said. It's covered all the cases that have been completed, regardless of when they were started. They were completed in 2018 and 2019. The statistical data will be dealt with in greater detail later. The objective of the survey was for us to assess how disciplinary proceedings were pursued and how these bodies operated, how these disciplinary infringements were sanctioned, and how the infractions of the Code of Legal Ethics were penalized. We used both quantitative and qualitative data, so we used a number of case studies which proved highly applicable to this research. We analyzed all of these procedures to see where the challenges and where the issues arose with the pursuit of disciplinary proceedings. I believe that the findings are highly significant, and I feel that the Niš Bar Association, which has shown such great interest in participating in this survey, because they themselves wanted to gain insight into what's been done, and we believe that this survey will serve as groundwork for them to understand their operations better. Thank you very much. Now, I propose that we move on to the presentation, and I'm going to ask the presentation to be shown on the screen. There we go. This is a slide that shows the objectives of the survey and the actual subject matter of the study. Now, I wanted to add that case studies covered 40 randomly selected cases, in addition to all of the other cases that were completed in 2018 and 2019. We particularly analyzed 40 cases. We took a deep dive into the case files for those 40 cases. I'd like to thank our researchers. Now, in addition to Bojana Arsenijevic, who's here with us today, we also had Katarina Momirovic, who helped us collect and process the data. And I'd also like to thank Katarina Ristic, who is an associate at the Niš Bar Association, and she provided a great deal of highly valuable support. And also we'd like to thank the president of the Bar Association, who guided us in our work and provided clarifications. So this was a joint effort, and this is how I view it. So if you could please pull up the second slide on screen. Bojana, I think you're best placed to address this. Thank you very much, Professor, and I'd like to thank you in my own name and in Katarina's name for the opportunity to involve us in this research, which has allowed us to learn more about how studies such as this should be performed. Private individuals, businesses, and government bodies can file disciplinary charges. Also bodies of the Bar Association, and lastly, disciplinary prosecutors can also initiate disciplinary cases ex officio. And in this period, we took a look at which of these authorized parties brought disciplinary charges. A total of 272 charges were brought. Of these, 88.6% were brought by private individuals. Much fewer were brought by businesses and government authorities, also by bodies of the Bar Association. There was only one case, or rather 5 cases, were brought by bodies of the Bar Association, whereas the disciplinary prosecutor did not bring charges in any case ex officio. Obviously, what we ought to note was that these data covered the 2-year period covered by the study. This is not an assessment of the total body of data retained by the Bar Association. Next slide, please. Now, here we have the number of cases opened in the observed period. Of the total of 264 cases, as many as 220 were also opened in the reporting period. Now, this means that most disciplinary cases, 84.25%, were completed within the same year in which they were brought, which statistically indicates a fairly large degree of efficiency of the disciplinary bodies. The next table shows how the disciplinary prosecutor handled these cases. After receiving disciplinary charges, the disciplinary prosecutor needs to review the case and to decide whether to reject the charges or to bring an indictment. Of the 264 charges brought, 250 were rejected by the disciplinary prosecutor, so it's 94.69% of the total. Only 10 indictments were brought. Interestingly, of the 10, the prosecutor withdrew the indictments in 2 cases. Next slide, please. Now, given the central role of the disciplinary prosecutor in these disciplinary cases and in the assessment of the cases in terms of whether they ought to be dismissed, rejected, or whether indictments should be raised, we felt it was interesting to look at the actions of disciplinary prosecutors in greater detail. No single case was brought ex officio in the reporting period. We also identified that disciplinary prosecutors made decisions only based on the allegations in the charges that were brought and also allegations in the lawyers' comments or responses to these charges. The disciplinary prosecutors did not take any investigative action to determine the merits of the case, although they are empowered to do so in accordance with the statute of the Bar Association. Nevena will tell us more about this when she explains the qualitative assessment. Another conclusion that we were able to draw was that there were no cases in which the disciplinary prosecutor asked for a temporary bar on practicing law. In cases where this may have been justified, based on obviously on the circumstances we were able to identify. On the next slide, we can see the status of the indictees in the 10 indictments and their structure by gender. We wanted to see whether trainee lawyers were also indicted before the disciplinary court, and this did not happen in the reporting period. No indictment was raised against a trainee lawyer. It seems that generally trainee lawyers are not subject to disciplinary sanctions. Of the 10 lawyers who were indicted, both men and women, 9 were male and 1 was female, so 1 was a woman. On the next slide, we've shown the structure of the infringements set out in the indictments. 10 were serious violations, and or rather 10 of the 10 violations, 6 were serious and 4 were minor. Of these 10 indictments, 6, as I've said, were serious and 4 were minor. Moving on to the next slide. After the disciplinary proceedings were complete, the disciplinary court ruled on whether to uphold the indictment and to find the lawyer guilty or find them not guilty, so to acquit them in these cases. In the reporting period, our sample demonstrated there were 2 convictions, and also in 2 cases the lawyers were acquitted. In 4 cases the indictments were withdrawn due to statute of limitations or due to withdrawals. Of the 272 charges brought in the reporting period, only 10 resulted in indictments, and in the final instance we had 2 convictions. If you could move to the next slide, please. The rulings of the disciplinary court and the disciplinary measures imposed in these 2 convictions were, 2 of them were fines. There were no reprimands, and there were no instances of disbarment, either temporary or without a particular time limit. 2 of the convictions were appealed, and both of those appeals were rejected, and the first instance convictions were upheld. Moving on to the next slide, which is the last slide in our statistical section, we here processed information about the duration of the cases. Most of the proceedings, as many as 39.39%, were completed within 6 months of being initiated. 30.68%, slightly fewer, were completed within 3 months. Adding to this, the number of procedures completed within 1 year reveals that as many as 94%, an impressive figure, of all cases were completed within less than 1 year. Now, when we compare this with the number of disciplinary indictments or disciplinary charges that were rejected, a fairly similar percentage, it seems that such high efficiency of the disciplinary bodies seems to have resulted in this large number of rejections of disciplinary charges. Now, obviously, the disciplinary prosecutor faced rather tight deadlines. 8 days are the deadline for the lawyer to respond to the charges, and it was desired and it was expected to see that the largest number of cases were completed within 3 months or fewer than that. So these are the data that we obtained in our study. So this concludes the presentation of our statistical figures. Now, what has this analysis shown us? Well, the first thing that becomes obvious when you apply the qualitative method to the 40 case studies that we examined in greater detail. Now, these figures show, and these findings show, that many charges were filed against one and the same lawyer. So there are about 30 attorneys at law, 30 lawyers, who have been subject to very many disciplinary charges. So 32 of the charges were brought against lawyers who'd already been subject to charges. And in 27%, the previously filed charges were dismissed. Only in 5 cases were actual proceedings pursued and actual rulings made. Now, what we can also take a look at from these complaints, when you look at what these lawyers' clients allege the lawyers did, mostly these are male lawyers, there was only one woman who was indicted. So what we can see in this regard is that lawyers' clients often complain and often allege in their complaints there is poor communication between the lawyers and themselves. So this communication is poor because there's very little information that lawyers provide to their clients. In addition, the information that is provided seems to be poorly adapted to the fact that these clients are lay people, they're not legal experts, and this leads to misunderstandings and often leads as well to disciplinary charges being brought or complaints being brought against these lawyers. Now, what the complaints show us as well is that there is often a poor relationship between the lawyers and their clients. There is little rapport between them, and there is very little tact on the part of the lawyers, who seem to understand what the position of the clients is. There's little empathy, little understanding for the totality of the client's circumstances. All of this also shows that, or shows up rather, in the complaints lodged by the clients. What the complaints also show us is that members of the public have little awareness of the powers and the obligations of lawyers, in particular how lawyers' fees are assessed and how they are calculated, lawyers' fees and reimbursement of expenses. And this seems to come as no surprise if you take a look at what the Bar Association's websites show, both of the National Serbian Bar Association of the Niš Bar Association. The information provided on these websites is mainly directed at the Bar Association members, so lawyers. Obviously, this is a good thing because it shows a desire for these operations to be transparent and for this information to be available to the Bar Association members. But there is very little information that is aimed at potential clients, at people who will, in point of fact, use these legal services. The law on the legal profession is up on the website, and the legal code of ethics is there, but obviously this might be more difficult for lay individuals to understand these legal provisions. So it might be worth noting that bar associations, both the National Bar Association, the Niš Bar Association, and other bar associations throughout Serbia, should take greater care to offer more understandable information to people who have no legal education. Also, to avoid situations where complaints are filed that are deficient, that they're written in plain language. Obviously, there's no other way that they could be written, because they're written by people who are not legal specialists. So, in other words, to guide clients in how to draft these complaints, it might be useful, and other bar associations throughout the world do this. They will develop a template for a complaint that should guide those who wish to draft complaints and lodge them with the Bar Association. We were also able to notice that members of the public were ready to highlight the breaches of the code of ethics by lawyers, even in situations where they themselves were not the injured party. You will see many of these complaints allege infringements of the code of ethics, breaches of law, and so on, even in cases where the actual complainant has not been an injured party due to these untoward actions by the lawyers. Now, this shows that there is a great deal of awareness on the part of the public, and there are huge expectations on the part of these people of what they want to expect, or of what they expect from lawyers. Now, moving on to the assessment of procedural actions by the disciplinary prosecutor. Now, what we've been able to see here, and we've mentioned this previously, is that charges are often dismissed. In 34 of the 40 cases that we reviewed in our case studies, the charges were dismissed. In 8 of these cases, this occurred due to the operation of the statute of limitations. And these are rules that people are not aware of. The statute of limitations, rather the relative statute of limitations, is 6 months. Now, this is something that the website should include so that people are aware of when they need to file these charges. And we've had charges that were not filed in due time due to the operation of this statute of limitations. Also, the operation of the absolute statute of limitations period was noted as a reason for dismissal. And you see that there's cases in which a large period of time has elapsed between the alleged action and the filing of the charges. A particular cause for concern is the fact that disciplinary prosecutors will rarely seek additional information, additional evidence. They will tend to rely, in making their decision, on what the actual allegation says. Now, the disciplinary prosecutor is obviously able, they're empowered, to investigate the case and to collect information from the complainant and from other individuals, other parties, other authorities, to collect information from them to shed full light on the case. Also, another aspect that we've identified is the prosecutor is fully focused on the infringements set out in the complaint, and they will not seek out evidence and information about any other infringements that may be suggested by the description of the case in question. For instance, in one case, the lawyer, without holding back, actually said that they received 300 cases to process. These were all owners of land in an area subject to flooding, and the lawyer was unable to verify those allegations in the 300 cases that they took on. And because of this huge workload, the lawyer acted under a power of attorney that was issued by a person who had died. And here the complaint was dismissed due to the operation of the statute of limitations, but the disciplinary prosecutor relied on the facts of the case and relied on the response of the lawyer to the complaint. And given that information, they could have and should have investigated the case further. The explanations for the dismissals are rather curt, both on the actual merits of the case and in the event of the statute of limitations. The explanations will summarize what the complaint sets out, what the lawyer stated in their response, and instead of a proper legal assessment of the case that would reveal that the disciplinary prosecutor was able to assess the facts of the case and the evidence submitted, there is often a simple sentence saying that the above does not indicate that the infringement was in point of fact perpetrated. So there's very little proper legal explanation that one might expect from any lawyer. In this case, the disciplinary attorney, or disciplinary prosecutor rather, should always set out a full explanation for the decision that they're making. So to convince the reader of this statement of explanation, of the fact that anybody would have made the same decision when faced with the same evidence. Now, these scant explanations often lead to the original complainants objecting because there is no proper accounting of why a decision has been made. A frequent argument to dismiss a disciplinary complaint is that the complainant was not injured. Now, without going into the veracity of the allegations, the disciplinary prosecutor will say that the complainant was not injured. In some cases, some complaints might be filed frivolously or to discredit the lawyer in question. This is something that tends to happen anywhere, and in that regard might also happen here. But the assumption must always be that each complaint is lodged with the intent of indicating an infringement, and this is why all the complaints should be treated as such. Whether there were violations or not, well, in the event of serious infringements, some serious infringements by their very nature do not lead to any sort of injury to the complainant. So a complainant might lodge a complaint to allege a breach of ethics, even without not having faced any sort of injury personally due to that breach of ethics. And often objections against dismissals in 12 cases of the 40 cases complaints were lodged. So to summarize, what do these decisions of the disciplinary court tell us? This is a cause for concern. Of the 264 complaints, only 2 resulted in convictions. This is what the procedure looks like. So you've got the complaint that's lodged and then all the procedural actions, and in the end these all resulted in only 2 convictions. And this is something that is a real cause for concern. The explanations are rather scant, as I've already pointed out, and in many of these cases that we looked at in our case studies, the dismissals occurred due to the operation of the statute of limitations. And this is something that really should not happen, given the statute of limitations rules and the fact that any action taken resets the clock on the statute of limitations. But in cases where hearings are convened, there's often more than 3 months between hearings. In some of our cases, more than a year would elapse between the time the indictment was brought and the first hearing was convened. These data ought to be looked at in greater detail. Now, I'm sure, given the openness of the Niš Bar Association and the support that we've received from them in this survey, that these findings will be reviewed by their board of directors and by all other bodies of the Bar Association, and they should also lead all of us to pay much greater attention and to do much more to address these issues. Lawyers themselves, as well as members of the public, but primarily lawyers and the bar associations, such as the Niš Bar Association, they all should have this powerful motive, given these findings, to deal with their members who breach these standards. And there are far fewer of these than there are brilliant lawyers who adhere to all legal and ethical standards and who've never been investigated or complained against. So there should be an investigation to see what can be done to make sure that there's a proper reaction to this, that there's proper convictions made following these complaints. And this is a procedure that needs to follow the rules of due process, not just to make sure that it's efficient or quick. But there's definitely room for improvement of the disciplinary bodies of these bar associations. So if there's recommendations that we can make, some of them include the following. More information should be given to members of the public about their rights and powers and duties, about both theirs and those of their lawyers, also disciplinary accountability of the lawyers and disciplinary procedure, and it might be also fairly easy to introduce e-filing for disciplinary complaints in accordance with the progress made generally in Serbia. There should be also brochures, leaflets about disciplinary accountability that should be available at all law firms, at all offices of lawyers, and lawyers ought to offer their clients these leaflets that should set out the key information about lawyers' duties and powers. Perhaps also template disciplinary complaints. Disciplinary complaints, as I've said, might also be made available online. All of these are issues that should be considered. These are all food for thought. Also, communication skills of the lawyers should be improved to avoid all of these misunderstandings, misunderstandings that may lead to more complaints, and those lawyers who fail to communicate properly with their clients should be disbarred. The Bar Association should exercise its own powers to lodge complaints more often. The disciplinary prosecutor should use his or her powers more often as well, and those powers should be used to fully clarify the facts of the case. When you read these cases, some of them are so poorly described that you don't even know what's actually happened. Even where the complaints are dismissed, there are, so to say, holes in the description of the case, of what's happened between the lawyer and their client. There should be better explanations, statements of explanation of why complaints are dismissed, also greater efficiency of the disciplinary bodies, and lastly, there should be a re-examination of the statute of limitations rules for disciplinary proceedings. Now, we said that we wouldn't analyze the statutory framework, but it ought to be said that there is some confusion as to when, for instance, a disciplinary offense is something that lasts for a longer period of time. When do you, or where does the statute of limitations kick in? Now, this should also be reviewed. And the initial perspective should be that the members of the public are allies of the Bar Association that help it counter these behaviors that are contrary to the legal code of ethics, that help the Bar Association identify these illicit actions. And each complaint, even where when it's obvious that it's lapsed due to statute of limitations, the complaint should be provided to the lawyer. They should be asked to comment on it, because the lawyer has a right to know what their clients might complain about, because those clients might recommend the lawyers in the future to their acquaintances, their family members, because advertising is banned for lawyers in Serbia. So the best sort of advertising is word of mouth in this case. There's a great deal of work that we're facing in this, but on behalf of this team of ours that we've assembled here, I can say that we've worked very well with the Bar Association. Hopefully that will continue, and we will remain available to help with any improvements. Well, thank you very much. Thank you very much for that, Ms. Čirić. Many findings have been presented that clearly highlight some of what the Niš Bar Association has been doing. So, first of all, I'd like to thank you on behalf of the Bar Association for being here. What can you tell us about these findings from the point of view of somebody who has taken part and still does in disciplinary cases, a disciplinary judge and a member of the Bar Association? Well, I've been a member of the Bar for about 20 years. I've been a disciplinary judge for the current president of the Bar Association and for the previous president. These statistics are true, obviously, but it ought to be noted that the disciplinary court has to comply with the law on the legal profession and the statutes of the Serbian Bar Association and the Niš Bar Association and the Code of Professional Ethics for Lawyers. The disciplinary court gets involved once the disciplinary charges are upheld, once the disciplinary prosecutor submits the charges, forwards them to the court. Now, all of these charges have been filed by private individuals. Only one case that I handled was filed by a business. No cases of mine were ever initiated by the disciplinary prosecutor ex officio. The law, in fact, does not make us a court. We don't have a bailiff. We are only able to serve court documents on the lawyer to the address where they're registered with the Bar Association. If they fail to respond twice, we will post the indictment on the court notice board. At times, the lawyers will pick up the letter from the post office. Then they have 8 days to respond. Sometimes we will schedule a hearing and then they will tell us that they're unable to come, that they're away, that they're off sick. At times, lawyers will hire their own counsel, but then they will tell us that they are unable to find a defense counsel for a hearing and that will be postponed. Now, all of these circumstances mean that statute of limitations will at times apply. Now, I don't wish to criticize the second instance body, but we have had a great deal of issues with the second instance body. The Niš Bar Association has always acted in good faith and adopted its decisions appropriately, but the Serbian Bar Association has proven inefficient, and the lawyers understand this. So, for instance, the president of the Bar Association is aware that a case was handled by the Serbian Bar Association for 8 months. From October to July of next year, the case was never returned to our Bar Association. And all of that means that it's highly likely for the statute of limitations to kick in. Now, these time limits are rather tight. I agree with the professor in that the Bar Association could produce template complaints, but my colleagues at the Bar Association and myself, we've often seen people come in asking for information and get that information from the staff at the Bar Association. So the Bar Association is available to all members of the public. I agree with the need for a template complaint. I also agree that the website should be improved to help any possible complainants, but I also believe that there should be changes to actual legislation in terms of the time limits involved. Those time limits would make these proceedings much more efficient. That is true. Well, thank you very much for this. Now, before I give the floor to Mr. Čolak, as he will moderate the rest of the discussion between the people who've joined us via Zoom, let me first of all give the floor to Mr. Čolak, and then we have 2 more people online waiting to join the discussion. Well, thank you, Dragan. I'd like to thank all the guests there in the studio. Well, we'll have a number of participants in the discussion who have applied to join the proceedings previously. Now, both Nevena and Bojana are members of our program council at the Judicial Base South. Let me also reiterate, as you said, that the approval from the Niš Bar Association for us to conduct this survey has been a pioneering step. The Bar Association has been open to something that bar associations haven't proven open to previously. So we'd like to thank the president of the chamber, Mr. Goran Pantic, and obviously yourself, Natasha. Obviously you're here on behalf of the chamber. If I'm not mistaken, Katarina Ristic has also been very helpful when this survey was performed at the premises of the Bar Association. Now, let me introduce a number of our participants. We will firstly have Ms. Katarina Golubovic. She is the president of UCOM and a lawyer based in Belgrade. Katarina, you have the floor. Well, good morning to everyone. First of all, thank you for completing this pioneering undertaking. I'd like to thank the research team, Nevena, Bojana, and both Katarinas, for compiling these data that are the basis for our discussion, and also the data will inform improvements to the Niš Bar Association. The Niš Bar Association has helped us take this pioneering step, and I'd like to thank them from the bottom of my heart. I believe that we now have a firm basis for our discussion. We can rely on both statistical data and on the in-depth findings of the case studies that you've presented. Well done. I know how difficult it is to take this first step towards transparency, how difficult it might be to take part in this research, because I've had the opportunity of working with Ms. Petrušić on a similar task, albeit in a different field. So definitely well done. Now, something that I'd first like to focus on is this piece of information set out in the assessment. So who actually lodges these disciplinary complaints? Now, these are mainly private individuals, as the findings suggest, and this raises the issue of the extent to which the judiciary is ready to defend itself and to enhance public trust in the judiciary by allowing complaints to be lodged for abuses of procedural powers committed by lawyers. Now, we often see reports in the media of cases that are highly interesting to the public, that are highly significant for public trust in the judiciary. We can see that those cases are often postponed. These abuses of procedural rights are showcased in those cases. Now, one of the takeaways that we could have from this finding is that the disciplinary prosecutor ought to use these complaints, these allegations, to take particular steps, but also the judiciary as a whole should be more involved in investigating these issues. This is one of the primary findings that this assessment has shown, and it's certainly one aspect that ought to be focused on more closely in the future. Also, this assessment has shown why these members of the public complain. So what it is that they believe is abuse by lawyers. Now, communication with members of the public has already been highlighted as an issue. The openness of the lawyers, their ability to explain what their powers are to the members of the public. So, for instance, how they calculate their fees and who's entitled to a waiver of these legal fees. Now, the findings suggest that the Bar Association itself ought to join other authorities and other stakeholders in improving communications with the public. Now, how did the Bar Association of Vojvodina, I believe, view its role. I believe that their view is wrong, and let me explain what I mean by this. When UCOM, the Committee of Lawyers for Human Rights, which has been working on these issues, so for instance, how members of the public can better understand their procedural entitlements, how they can understand better how these things work, one of the bar associations argued against information presented in our guide and felt that the guide was not useful in explaining these powers. So this assessment should help you understand what your role is with regard to the general public. So you should be proactive in systematically removing the causes of dissatisfaction of the general public with the legal profession. I myself am a lawyer, and I understand that sometimes lawyers might have high workloads that might lead to neglect of a particular client, but I cannot justify that. There are ways in which members of the public can get information about what their lawyers can do, and the lawyers ought to be able to devote some time to effectively communicating with the public. Now, this assessment has revealed this information more in greater detail, and I'd like to thank the researchers for that. Interestingly, members of the public are particularly active in complaining about a particular number of lawyers, and that's a sign for the Bar Association. First of all, perhaps to perform this type of analysis more often, so that the Bar Association is able to better understand how it's handled some of these cases and what its decisions have been. So this effort should continue, and the Bar Association ought to improve what it's been doing in this respect. Now, the Niš Bar Association has said that the disciplinary prosecutor has almost never initiated any of these cases ex officio. This has to change. It was telling that before I joined this meeting, I got a call from a newspaper here in Serbia asking me to comment on some information that they had received about ourselves, UCOM, having lodged a complaint against a lawyer last year. Now, the cause for that complaint, and yes, we did lodge that complaint, but we did so because at times actions by lawyers can be highly damaging to public trust in the judiciary, to public trust in the legal profession, and lastly, these actions can hurt the independence of the legal profession. All lawyers have to be independent, and this is something that we've been highlighting as a major tenet of what we do. And this is why we are sole traders. We have that status according to the legal profession law, and this is all geared towards helping us preserve our independence. And then when you see somebody infringing on that independence, jeopardizing the reputation of the legal profession and hurting trust in the judiciary and in law enforcement services and so on, you need to react. We, for instance, have had no information for these past 4 months since we lodged that complaint, whether the complaint has been reviewed yet. And that's another indication of the lack of transparency of this process and the extent to which the complainant can actually impact these affairs. Now, Professor Petrušić has said that service of process might be an issue, and that the use of evidence and also electronic communication. the procedure is quite tightly regulated in Serbia. We weren't able to use hyperlinks, for instance. In our complaint, we had to provide CDs with audio and video material that substantiated our allegations. So this is, in a way, a disincentive for the complainant. Complainants ought to be given much more opportunity to be able to lodge these complaints, and bar associations ought to be more active in taking these steps, especially when it comes to these highly prominent cases, because those highly prominent cases do the most damage to the judiciary and to the public, and so on. Now, let me not hog the floor. I think I've spoken too much already. Thank you, Katrina. This was an inspiring intervention. Hopefully you will stay with us for the rest of this event. It might be very interesting to look at the statistics of other bar associations to see whether other bar associations have such few complaints lodged by the disciplinary prosecutor in those cases. We have heard at the start of this event that lawyers communicate with chambers using telegrams. This all sounds very quaint nowadays in the 21st century. It seems not so much as an attempt to communicate effectively as to avoid communicating effectively. Let me now introduce our next participant, Stefan Vlatkovic. He is a lawyer based in Niš, also a member of our judicial base, somebody we've been closely cooperating with here in our coalition. Stefan, you have the floor. Thank you, Mihailo. Now, first of all, I'd like to welcome all of the participants, and I'd like to thank our researchers headed by Professor Petricic. Their research, the data that they've collected are very important, not just for the practitioners, but for the general public as well. I believe that many people from my immediate social circle had no idea about the statistics from these disciplinary proceedings and what the outcomes have been. And I believe that the conclusions of the research team will motivate both the chamber and the lawyers to improve their performance and to make sure that the disciplinary proceedings are more efficient. There are two issues that I'd like to touch upon, which I feel are important and ought to be considered as part of this discussion. Firstly, one of the conclusions of this survey, one of the recommendations, is related to the procedural position of the complainant. More specifically, the standing of the complainant as the party eligible to object to a ruling of the disciplinary court. Now, I believe, in my opinion, that this is akin to the position of the injured party in criminal proceedings. Now, in those cases, the injured parties are able to complain against decisions on whether to raise indictments. Now, the researchers suggest that these rules ought to change. So I would like perhaps to ask them to comment on this issue. Now, what is this conclusion based on? Why do they believe that the rules ought to change, since they're closely linked to the rules as set out in the Criminal Procedure Code? Now, does this mean that the disciplinary prosecutor has been failing to appeal acquittals by the disciplinary court? Do they believe that it's in the interest of the complainant to appeal given the role of the disciplinary prosecutor, which is to protect the public interest. So does this mean that the private interest of the complainant is jeopardized by the fact that they're unable to appeal these rulings? Dragan, I'm going to let you direct this question to one of the guests in the studio. Well, I think that if that was the question, that in this survey we did answer this question. One of the recommendations is, given that the statute of the Serbian Bar Association does permit the Code of Criminal Procedure to be applied as appropriate to these proceedings. So guided by that idea, the changes that have taken place in the Code of Criminal Procedure should also be reflected in the disciplinary proceedings. And I think that in our discussions, we came to the conclusion that this survey could serve to improve performance both as part of the current legal framework, but also to make sure that statute of limitations rules and statute of limitations periods of time and the ability of the complainant to appeal, that all of that should be reflected in the disciplinary proceedings, and there should be a much more thorough assessment of all of these issues amongst legal professionals. The legal framework certainly could be improved, but we want to avoid ending up with a conclusion that says that the problem and the challenges of disciplinary proceedings are actually driven by legislation. So a lot could be improved in legislation, but also we need to understand that this framework, such as it is, still does allow much in the way of good performance, provided that all parties do as much as they can. It's simply impossible, it's inadmissible to have only 2 convictions out of all of these disciplinary complaints. Now, I also wanted to say that poor communication between lawyers and clients should not be considered as the primary issue. Obviously, this does happen. Many people have pointed out the fact that communication ought to be better. But in our cases that we've analyzed, it was eminently clear that there are some lawyers who are in flagrant breach of their duties. They, for instance, when they seek collection in enforcement proceedings, they will leave their own bank account number, so the money is paid into their account rather than into the client's account, as should happen. So we need to be aware of the fact that there are cases here which have failed to be convicted, or which have failed to result in convictions due to the application of the statute of limitations, even though they were flagrant breaches of both moral and ethical standards. Let me also say that a moment ago I was listening to Katarina carefully, and I did say that the disciplinary prosecutor did not bring any charges ex officio, but this was the case only for the period ending in 2019. I am told that currently there are proceedings in progress that have been launched by the disciplinary prosecutor, so that's very important. And I would also tend to agree with the statistics and the conclusion that some lawyers have had complaints lodged against them more than once, so frequently. And it's the task of the Bar Association to get to grips with these adverse phenomena to the best of its abilities, and to find solutions that will not infringe on the rights of the members of the public. Mihailo, has anybody asked for the floor in the chat? I can see somebody's got their hand up. Milan Jovanovic wants to come next, I would like to use this opportunity to invite all the participants to come in if they want to. Please do either type in your question in the chat window or raise your hand. There are our judges here, prosecutors, lawyers who are officers of their local bar associations. We have CSO officials, members of the public. So there is quite a varied audience today with us. Stefan, was there anything else you wanted to add? Yes, I did say that I would have 2 topics for discussion, and this is my second topic. This is not directly linked to the survey as such, but it does deal with the rules about the legal profession and the statutes of the Bar Association. So it's about the role of courts of general jurisdiction in applying these rules, and not to reassess whether the bar associations have made decisions properly, but rather in various civil cases where lawyers have not taken part in. For instance, can the courts sanction abuses of lawyers' rules concerning conflict of interest, or breaches of duty in cases where lawyers refuse to represent their clients? There are cases in progress with the European Court of Human Rights, and that court has often said that lawyers who abuse procedural rules before that court can be threatened with the court denying them the right to plead cases before the court. So perhaps that's a topic for discussion. Could Serbian courts also use abuse rules, including compensation rules in the event of abuse, or cases, rules that refer to other abuse? Could the courts therefore use those rules to deny lawyers who've been repeatedly in breach of the statutes and the ethical rules, to deny them the right to plead cases before those courts, or if they face conflicts of interest? I have not seen any such cases to date where a court of general jurisdiction would bring charges against any lawyer. I am only aware of a case of one lawyer, a colleague of mine, where the president of the Bar Association was notified of this, but I've never seen a court bring disciplinary charges. In our sample, the sample that we studied, we had one such case. This wasn't a disciplinary charge, a complaint. It was, in effect, it was titled as a notice that described the alleged conduct of a lawyer, and this was sent to the Niš Bar Association, and the disciplinary prosecutor properly treated it as a complaint and acted on it accordingly. I think it was an issue with power of attorney. Yes, it was about a power of attorney. And what I and all of us ought to bear in mind is that we expect the judge, the acting judge in the case, to use their powers in the court case to react to any type of abuse. Abuse of powers, for instance, or infringement of rules governing order in the courtroom and so on. And we have, in our procedural laws, we have instruments that judges can use in those situations. But to the best of my knowledge, and based on the findings of other surveys that I've been able to read, it's quite rare for a judge to use those powers and to penalize somebody for abuse of procedural powers. It's even rarer for proceedings to be brought for compensation due to abuse of procedural powers. Now, issues such as what is allowed and what's the reach of procedural powers and to when should they be considered to be abused, this is all rather flexible in the heads of our legal professionals. So the view is often widespread that whatever's in the interest of the client should be allowed. Obviously, that is not so. There were also cases where complaints alleged the particular instances of behavior of lawyers in courtrooms. There was one case where the lawyer was alleged to have acted improperly within the courtroom, and the prosecutor, in this case, the disciplinary prosecutor, wished to understand what that conduct was about. What did they find important? They had to look at the court minutes, so the record of the hearing submitted by the lawyer, and that record, the minutes did not reflect or did not show any penalty due to this abuse, which is why the prosecutor concluded that there was no abuse, because otherwise the judge would have penalized the lawyer. And the prosecutor ignored the fact that it's so rare for anybody to be penalized for abuse within the courtroom. You had to assess what they said, how they behaved, and then apply standards of the legal profession to understand whether there was any abuse there. So this in and of itself is not proof that there was no abuse. So the absence of any penalty is not proof. Yeah, it's an additional reason for the disciplinary prosecutor to go one step further to perhaps bring charges. Mihailo, sorry, I think that I saw Milan Jovanovic ask for the floor. Milan Jovanovic is vice president of the Justicia NGO, civic association. He is a judicial associate at the court of Niš, and by virtue of being an officer of Justicia, he is a member of our coalition. You have the floor. Well, thank you, Mihailo. Thank you for that introduction. First of all, I'd like to join my fellow participants in congratulating the team and thanking them for conducting this research. I've read the report, and I'm pleasantly surprised by the comprehensiveness with which you completed the survey, and that's specifically important due to the importance of the topic. And I know I have first-hand experience in producing such studies, and I know how difficult it was to analyze 40 cases and reach conclusions. Just a number of impressions here. One thing interesting for me, also shocking, that I was able to find out during this 1.5 hours, 95% of all cases, of all complaints, were dismissed. Of the 270 plus complaints, we had only 10 convictions. Now this tells us, I believe, that the system is inefficient. It's not as efficient as it ought to be. Now, this is what I was aiming at. We have been discussing disciplinary accountability before bodies of the chamber. However, it seems to me that there is a trend to understand this as an internal matter for the legal profession, something that the legal profession in and of itself can address, can deal with. I believe that this is not the case. I think that the chamber, when it handles disciplinary procedures and when it administers those proceedings, that this is a form of public authority. So if it hadn't been given to the Bar Association, it would be would reside with another public authority and be exercised for the benefit of the public. Now, I believe that is self-evident. When disciplinary bodies exercise their powers, and when the prosecutor then brings charges, they do so not just to the benefit of their members or the complainants or the clients, if they're the complainants. They do so to the benefit of us all, to make sure that the legal profession, which is designed to provide legal assistance, for the profession to be rid of any adverse phenomena that do tend to appear in any profession. any organized group of people. So in that regard, I feel that the conclusions of the study ought to be upheld, they ought to be supported, and the disciplinary proceedings should be made clearer to the public. Now, we know that if the lawyers will not bring charges due to issues of comity, and courts will not do so for other reasons, it's incumbent on the members of the public, because they're the ultimate beneficiaries of this, it's incumbent on them to file these charges, and they would best do so if there were templates, if it were made easy for them to do so. The key issue here, I believe, is that in such a system, ex officio proceedings should be the norm, where the disciplinary prosecutors should undertake investigations on their own accord. I believe that Bojana said there haven't been any investigations in all of these cases that resulted in complaints. And many of these cases do not even merit specific investigation, but in the cases of the 30 quote-unquote usual suspects, those who are often complained against, that in their cases, the prosecutor ought to go beyond what's alleged only in the complaint, because there ought to be an assumption that there is a reason underlying the complaint. And if there are any omissions, if there's anything untoward going on there, it's not necessarily in the complaint, but could be found through a broader investigation. But to protect the interests of the legal profession and to ensure legal security, the prosecutor should act proactively, should go out and investigate cases even without a formal complaint being lodged. Now, when it comes to the efficiency of these proceedings, I know for a fact from personal experience, and I think that you mentioned the same case. There was this case where the proceedings were brought against a member of the Bar Association over a set of mass claims. Judicial Base South devoted a particular survey, a special survey to that, and those charges related to a lawyer who submitted a power of attorney or sets of powers of attorney that he signed himself on behalf of their clients. So he used copies of the same document. Even the court wasn't clear about what was going on there, and it then applied with the chamber to clarify that. That case is self-evidently an example of abuse. Now, that case did not result in any sort of penalty applied against the lawyer. So, such a flexible and tolerant approach towards abuses and infringements only allows these violations of the Code of Ethics to occur indefinitely and to become even more common. As we've heard, this means that these violations become more common, and there's a climate of impunity amongst those who infringe upon the rules, both in issues that have occurred and were not prosecuted, and for new instances of abuse that may not have ever been registered previously. And I think that this is a survey that is particularly useful, and I am looking forward to reading the whole survey and the case studies, because I believe that they properly reflect all the cases in Serbia. Sorry for taking so much time here. No, Milan, I don't think you've taken too much of our time. Thank you for that intervention. I think that you have a point. When we were communicating with Nevena and Bojana about this survey, we came to the conclusion that it would be good, after this survey, to develop a guide that a guide to disciplinary proceedings that would familiarize members of the public with their rights. So when indeed they are entitled to dispute the outcome of a case, and also to clarify when a lawyer is deemed to have infringed upon the rules. Members of the public often will bring charges against lawyers, and they will inundate the chambers with these cases that often have no merits. Such a guide would make it possible for the public to understand how they can bring charges, how they can complain, and this would also discourage those who bring frivolous charges, not necessarily due to any ill intent, but also just because of a lack of information. Milan, we know that we're living in an age of mass claims that started 10 years ago or more, and I think you were one of the researchers on that study. And there's a contradiction here. Lawyers advertise on bus station shelters, on public furniture, street furniture, and we've only seen 2 ex officio charges by the disciplinary prosecutor, even though such advertising is not allowed. Perhaps other bar associations obviously might have different data, but this is what we have in our region. Now, let me introduce our next participant, Mr. Srđan Mitic, President of the Disciplinary Court of the Serbian Bar Association. It's a particular pleasure for us to have members of the Serbian Bar Association with us. Mr. Mitic, you have the floor, please. Well, first of all, I wanted to say that this research is exceptionally useful. There are many things that hit the nail squarely on the head. The Bar Association of Niš is one of those bar associations that have allowed disciplinary bodies to work much more efficiently by hiring Katarina Ristic, who is a special associate there. As president of the Disciplinary Court of the Serbia Bar Association, I'm originally a native of Pirot, which is nearby, close to Niš, and I've met with all disciplinary courts of all bar associations that are part of the Serbia Bar Association, where we identified many of the issues recognized in this research as problems. I think our status has been seriously brought into disrepute. You mentioned this illicit advertising by lawyers. Many lawyers are still not aware that there is a disciplinary court, and I'm sure, and I agree, that charges should be published on the website. And the Vojvodina Bar Association has gone the furthest in promoting the court. On their website, they publish even the court's judgments, the court's rulings. Also, there's the issue of financial assistance to courts. For instance, disciplinary courts, for instance, we had situations where we had to summon a witness from Pirot or Vranje, or where we had to do handwriting research or IT research. Chambers, apart from that of Vojvodina, have to date failed to properly remunerate their disciplinary courts. So we are happy in that we are able to control our own work, to audit what we do, and we should use that opportunity. And when bar exams are taken, people who sit bar association exams, bar exams, have also the subject of ethics as part of their curricula, and chambers ought to use their ability to bring order to the legal profession. Thank you very much. And I think it's a very good thing that this research has been done. I'm particularly glad to see the Niš Bar Association as the one that has done this with the huge assistance of Professor Petrušić. And I think that this is a huge thing, and many chambers, I believe, will take the same road and take this research seriously. Thank you, Mr. Mitic, once again for that intervention and for taking part in this discussion. Thank you. Now, you mentioned the Vojvodina Bar Association, which seems to have been performing fairly well. We have an officer of the Vojvodina Bar Association here with us. I would like to encourage them to take the floor. Please raise your hand if you want to do so. But before that, let me introduce our next guest, Ljiljana Stojanović of Jug Press. She is the lead editor there at that media outlet and a member of our judicial base. She has told us about cases where members of the public would come in and tell her that lawyers had infringed on their rights and that they felt violated, they felt betrayed in this relationship. If you're with us, please, you have the floor. Lilja, if you're here with us, please go ahead, you have the floor. Good afternoon. Thank you, Mihailo, and hello from Leskovac. I'm a journalist, as you've been able to hear, and as such is my work. I often talk about specific issues. So there's a case that I think one of the researchers has already mentioned, is a case in which the public came to us to tell their story. And this was a case where a person wanted, or rather was involved in a dispute over the sale of a cow, and they got a judgment in their favor. The money was collected and the lawyer kept the money in their account for 10 years. The client did not realize that the thing had been finalized and only found out about this when they encountered the defendant on the street somewhere in town, and the defendant told them, well, now we're even, now the money was collected. And the client was shocked. They went to the lawyer to complain, and the lawyer insisted that the client owed them money. And this person was from a village close to Leskovac. The person came to the Bar Association in Niš and was turned away by the secretary there because she told him that this was not a case for them. And then that person obviously spread the word of around town. And when I asked lawyers in Leskovac, they told me that that lawyer was known to engage in such behavior, and this was nothing new. And that's a total disaster, and it's hugely damaging to the legal profession and damages trust in the legal system throughout Serbia. There was also a recent case where a local business owner physically abused workers in their workplace, and they retained a lawyer who is considered one of the best lawyers in Leskovac, and that lawyer tried to dissuade them from prosecuting the case by asking for their fee up front, although they had an agreement where the lawyer would get half of the compensation if they won the case. The lawyer told them in the meantime that they would charge them for each appearance in court, and the lawyer even told them that he would give them a discount, would charge them 9,000 instead of 16,000 dinars for each court appearance. Now, I am a graduate of the Faculty of Political Science. I'm not a lawyer by trade, but I do know a bit of law due to the nature of my work. I often ask for interpretations of laws. I often read laws out of general interest to understand what they're about. So the lawyer misled their clients the lawyer told them they were wrong to tell their story in the media. This was a fairly popular case in the media. And the lawyer objected to their telling their story in the media. There was another interesting case recently of a single mother. Her husband, former husband, the father of their child, was not paying their child support payments. And it turned out in the end that most of the money was spent on lawyers' fees and enforcement officers' fees. For instance, she only got 5,000 dinars over a period of 8,000 years. And this is a telling example. Now, let me also bring up a very quick example. Mihailo, I think I told you about this when there were floods in the vicinity of Leskovac. A young female lawyer in Leskovac misled a number of people. She charged them for having the local authorities commission survey their property to assess the damage. She asked them to pay 16,000 dinars each on pain of enforced collection. And when, first of all, some of those people met me in the street and told me that there was media interest in the case, and a word got around that the media were interested, and all of a sudden the charges, the amount was reduced, and there was no compensation from the city in the end. And the lawyer only wrote their applications, drafted their applications to the city, and they had to do all of the work besides that themselves. And they had no idea that they could draft those applications themselves without the intervention of a lawyer. So to come back to the beginning of this discussion, members of the public ought to be well informed. They need to know what they can do, what their lawyer can do, what the lawyer's obligations are, because in this way they're actually misled. You can theoretically tell a lawyer that you know what your rights are, but then the lawyer would say that they would have to use a lawyer. In the end, there are some people who went their own way without hiring a lawyer, and they encountered abuse from the legal profession, and this does not contribute to trust in the legal system and people working within it. Thank you, Lilia. It makes no difference that you're not a lawyer. Sometimes a lay person's opinion is more than relevant and interesting, and that brings us back to the conclusion that we should all work together to enhance the way that the public are informed, to make sure that they understand what's reasonable and what's not, and what can and what cannot be done. Thank you for your intervention. Now I'd like to ask the entire audience if there's anybody who'd like to come in, any comments, any observations. Until we have people applying to take the floor, Dragan, let me ask you to come back to the research team to see whether any of the guests in the studio would like to add anything. Thank you, Mihailo. Yes, the examples presented by Liliana have been heard well, and we have a comment here. Now, we had an example where a lawyer had represented a man in court, and the disciplinary prosecutor was unaware of the fee being collected but not remitted to the client, and that this could not be the subject of disciplinary proceedings. The only reason for that is that a long period of time had elapsed between this alleged instance of abuse and these people, this person coming to the Bar Association. But the Bar Association could have brought private charges against the lawyer, because disciplinary liability is subject to the statute of limitations. The child maintenance example, let me comment on that as well. Lawyers always notify clients that if it's a lengthy period for which they're asking for child support, this is subject to a statute of limitations of 3 years. And this is not something that can be achieved in court. I recently had a case where the complainant was asking for child support for 5 years back. They only got 3 years because 2 years were time barred, and the procedural costs were very high. There is a schedule of those charges that's available, and each lawyer will give their clients the table. They will allow them to inspect the table, and each lawyer will explain the fee structure for civil cases, criminal cases, and enforcement cases. Agreements between lawyers and clients regulate the lawyer's fee award. Their fee award is also regulated, and the example that you cited of 50% is completely unacceptable. That's contrary to the statute of the Bar Association, the Code of Ethics. Liliana's just told us in the chat that they did bring private charges, and they did report the lawyer to the police. I just wanted to relay what she said in the chat. That's before a general court. Yes, they filed standard civil charges, but the disciplinary court of the Niš Bar Association couldn't handle the matter due to the statute of limitations, because Liliana said that he'd found out 10 years later, and the disciplinary accountability lapses in 2 years. Sorry, yes, but the secretary there, the receptionist there, could have explained this. This is a man from a rural village, which you'd call a typical Serbian, quite clever rural individual, and the receptionist there could tell him that this had lapsed due to statute of limitations, but the person had brought charges with the police, and so on. As for the 50% fee, these people were asking for their power of attorney, for a copy of the power of attorney, and I'm sure whether the lawyer actually gave them a copy of that document. If there's an agreement that's been signed, the agreement, the first article of the agreement, sets out the costs of the proceedings, whether it's litigation, whether it's a criminal procedure, whether it's an administrative proceeding. There's a tariff for each. And the second paragraph is the fee award charged by the lawyer at the end of the proceedings. Thank you, Ms. Čerić. We have, Mihailo, we have one more applicant. This is Nebojša Stanković, Dr. Stanković, a lawyer of Niš, the author of our first report, the mass claims report. Nebojša, please, you have the floor. Good afternoon. Hello, Mihailo. Hello, Dragan. You're the organizers. Dear Professor, I'm glad to hear from you, and I'm glad to see the researchers there. They're all responsible for parts of this research, which was begun now more than 2 years ago. Now, without looking into these mass claims in greater detail, I've got to say that that part of the report has been successful beyond our wildest expectations. The professional public was particularly interested in those findings. But back to today's topic, the performance of disciplinary bodies of bar associations. Now, this is a unique survey. It's one of a kind. Now, I don't think that if you were to Google disciplinary proceedings, I don't think that you could find many media reports or other reports of that kind, but there are a large number of those cases still that are active. Now, what I wanted to add is that this study can motivate people with an interest to do something. Only statistics tell one story. If you see that 90% of all cases fail to result in convictions, that tells you something about the lack of justice in society. Now, given that the legal profession is self-regulating, and is particularly important in society, it's specifically safeguarded by the Constitution and by legislation, it's apparent that self-regulation and this protection, this unique nature of this profession, is not fully reflected in the accountability of the legal profession. Now, in practice, I have to say that I haven't come across a report such as this, and it, as such, is the groundwork for a future such examination. When it comes to the topic of the report, I won't be able to comment on that because I'm a lawyer myself, but Srđan Mitić, who also spoke before me, has said something that I can get fully behind. Now, if the legal profession remains bound by legal and professional regulations, I will always be in favor of making sure that bodies of bar associations are properly remunerated to make sure that they're active and independent. This might run counter to usual standards of the past. Things change, the legal profession changes as well, and I think that disciplinary prosecutors, both at local bar associations and the Bar Association of Serbia, have a great deal of responsibility and not just prestige that accompanies their office. And this means that they need to devote a great deal of time to examining these complaints and making decisions. Now, I think, both in a private capacity and here speaking publicly, believe that there should be changes to regulations that govern how disciplinary prosecutors are elected for a particular period of time. And during their term in office, they ought to be remunerated to be able to fully safeguard the public, but also to defend the legal profession. Disciplinary prosecutors don't just pursue cases against lawyers, they also defend them from frivolous or meritless cases. But this is a two-way road. But I think that this crucial issue can only be resolved if people who do this job, who perform this office, are properly remunerated and made properly independent in this regard. I would like to congratulate the researchers on their effort. It's difficult for me because the professor used to teach me at university and now I'm in a position to grade her work. But I think that this research has required a great deal of courage. And I think the researchers will understand why I believe that they've been very courageous. And unfortunately, there have been many who have been opposed to this research and still are opposed to it and are able and willing to criticize the report and will do so. But I believe that every word in this research is the fruit of years of study. It's backed up by analytical and statistical data, and we may look at the research from every angle, but it's going to be difficult to dispute any of its findings. Thank you, Nebojša. Now, I'd like just to add that this survey, this study, and the previous study on mass claims, and our upcoming open data study, all three are currently being translated into English, and we will have a large volume in which we will bring together all versions, all three reports in both languages. It's probably going to appear in late May or perhaps even before then. Everybody who's interested will be able to get a copy from Judicial Base South. Thank you, Nebojša, for your intervention. Dragan, back to the studio. Would any of the guests in the studio care to comment in conclusion? I think the end of our second hour is drawing near, and I think that I'm sure that people in the studio are feeling the strain already. Well, just briefly, if you have any comments about these final interventions, especially from Nebojša. I agree with Nebojša, and his recommendation has merit. The deputy president, the previous deputy president, has already asked for the disciplinary judge and prosecutor to be appropriately remunerated in the Bar Association. That was refused. Also, there was a proposal that our membership dues be used for that purpose, and this was also rejected. So currently the bodies of the Bar Association and members of those bodies are not remunerated. They work pro bono. Well, at the end, I'd like to thank all the speakers for the kind words that they've said about this research, and all of us who have contributed in a way to all of us gaining some sort of understanding over this quite limited period of time, admittedly, but this is a picture that is worth more than 1,000 words. And I'd like to say that I do believe that in the upcoming period, this is going to be a topic we will continue to deal with. There are many reasons why we ought to deal with it, both in terms of improving performance, and we've heard proposals to that end. Today, we haven't been focusing on how to improve the legal framework, but this ought to be taken into consideration, including whether officers ought to be remunerated or not. Those rules should be universal for all parts of Serbia, all members of the public, also lawyers throughout Serbia ought to face a level playing field in that regard. So there is room for us all to work together on this. It's in all of our interest, in the interest of both lawyers as well, for this profession to be honorable, to be equitable. This is a profession that is of enormous importance for the rule of law and for safeguarding the rights and liberties of the public. And I believe that the legal profession should enjoy the full trust of the public, and all of us can contribute to that from a variety of perspectives. Thank you. Bojana, any comments from you? Well, I won't miss this opportunity now to build on what the professor has said. Maybe this research could be the first step in a broader survey of the disciplinary bodies of court, of all bar associations and courts and judges and judicial associates throughout the country. Thank you, Bojana. Let me invite everybody to pay closer attention to the recommendations at the end of the report. And as you, Ms. Patrušić, said, we can all contribute. And on behalf of the Judicial Base South, I wanted to say that looking at these recommendations, we will certainly work with the Bar Association in the future. Thank you for this pioneering effort. We will work with you together to do all that we can to make sure that members of the public in whose interests we work find it easier to safeguard their rights in any area of the judiciary. Obviously, today we were referring to the legal profession. We will work together as allies, we're not opponents, and the public, unfortunately, still believe that money is the key to getting proper legal representation. CSOs and these initiatives ought certainly to work together to help, and will do so to dispel this stereotype and to dispel these prejudices by focusing on the accountability of individuals rather than on those who infringe on the rules. I agree. I only disagree that money is the key. Money, remuneration is not the key, but it is one of the options for enhancing efficiency. And then there would be more investigative actions taken by the disciplinary prosecutor and the judge. No, I wasn't clear enough. I felt that there should be a change of the view of the general perception of members of the public when it comes to lawyers. I fully agree with their requirement for disciplinary bodies to be remunerated. Now, Mihailo Nebusha's asked me in the chat to thank Mr. Pantic once again. We agree that it was he who needed the most courage to support this research. Mr. Pantic, the president of the Bar Association, has not only helped technically complete this research, he was also a consultant on the research, and he gave us a number of very important technical pointers as to how to complete the survey. And I'd like to again thank Katarina Momirovic, who was part of the research team who completed the survey. And thank you, Nebusha, for reminding me to thank Mr. Pantic once again. Right, in the absence of any additional questions, we have been here for 2 hours now. Thank you all for taking the time to join us. Thank you all for your interventions, for your recommendations and questions. Judicial Base South will go public towards the end of April once we present the study on open data in the judiciary, and everybody who would like to continue dealing with issues of the reform of the judiciary are welcome for us to contribute to these changes. Thank you all for your time. And hopefully this is going to be the last hybrid conference of this type. Goodbye from Niš.